Hello dear students, I, Dr. Anuradha Goswami, Assistant Professor, Department of Commerce from the Bhopal School of Social Sciences, welcome you all for the third module of the Indian Company Act 2013. The subtopics covered in this module are share capital, share certificate, share warrant, shareholder, director, meeting and resolutions. Dear students, let us understand the meaning of the term share capital. As we know, the joint stock company is a big form of business organization. The amount required by the company for its business activity is raised by the issue of shares. The amount so raised is called share capital or capital of the company. Share capital is a long source of finance and remains with the company till it goes into liquidation. The types of share capital are nominal, authorized or registered capital. Another one is issued capital. The third type is subscribed capital. The fourth type of capital that a joint stock company has, called up capital, and the fifth type of capital that a joint stock company with it has, paid up share capital. As per company law, the capital of a company is divided into following categories. The first type of capital is nominal or authorized, or we also call it as registered capital. The maximum amount of share capital that a company is allowed to raise is called its authorized capital. The second type of capital is known as issued capital. Now let us learn its meaning. The total value of the shares a company elects to sell to its investors is called its issued share capital. The third type is known as subscribed capital. Basically, subscribed capital is that part of the issued capital for which applications are received from the public. The fourth category of share capital is known as called up capital. It is that part of the subscribed capital which has been called up by the company. A company does not call at once the full amount on each of the share it has allotted and therefore calls up only such amount as it needs. Now take a look at the fifth type of share capital, which is known as paid up share capital. It is that part of called up capital against which payment has been received from the members on their respective shares in response to the call made by the company. Now students, I will discuss meaning and types of shares issued by joint stock companies in India. Let us understand the meaning of the term share. A company's capital is divided into small equal units of a finite number. Each unit is known as a share. In simple terms, a share is a percentage of ownership in a company or a financial asset. The types of shares issued by joint stock company in India are divided into two broad categories. Number one, it is known as equity share, and the second type of shares are known as preference shares. Now let us discuss these type of shares in a little detail. First, we'll discuss about equity shares. The first type of shares which are issued by the company. Equity shares are also referred as ordinary shares. Equity shareholders bear the highest risk. They are the owner of these shares and have the right to vote on various company matters. Equity shares are also transferable and the dividend paid is a proportion of profit being given to the shareholder. The second type of share is known as preference share. Preferential shares are basically preferential in nature. A preference share which receive dividend before ordinary share, but they have no voting rights in the matters related to the company. Now students, I'll explain share certificate, share warrant and shareholder to all of you. But first, let us discuss about share certificate. A share certificate refers to a document which is issued by a company evidencing that a person named in such certificate is the owner of the shares of the company as stated in the share certificate itself. Now let us understand what is share warrant. A share warrant is a document issued by the company under its common seal, stating that its bearer is entitled to the shares or stock specified therein. Basically, share warrants are negotiable instruments. Coupons are attached to each warrant. The person who produces the appropriate coupon can receive payment in the form of a dividend from the company's management. Dear students, as far as the meaning of the term shareholder goes, basically the shareholders are the real owners of the company. A shareholder can be a person, company or organization that hold stock in a given company. Shareholder receive declared dividend out of company's profit. Dear students, let us now discuss about the management of the company, which basically consists of the board of directors. So now we will learn the meaning and the types of directors. The supreme executive authority which controls the management and affair of the company vests into the team of directors, which are also known as board of directors collectively. At the core of the corporate governance practice, the board of directors oversees how the management serves and protects the long-term interest of all stakeholders of the company. The board of directors of a company consists of following type of directors. They are first director, resident director, women director, independent director, alternate director, additional director, small shareholder director, and nominee director. Now let us see these type of director one by one. Under the category types of director, let us understand the first type of director known as first director. As per section 152 of the Companies Act, which provides for the appointment of first directors accordingly, where there is no provision made in the article of association of a company for appointment of first director, then the subscribers to the memorandum who are individuals shall be deemed to be the first director of the company until the directors are duly appointed. The second type is known as resident director. The detail of resident director is given under section 149 subsection 3 of the Companies Act 2013, and it provides that every company shall have at least one director who has stayed in India for a total period of not less than 182 days during the financial year. The next type of director is women director. Every public company having a paid up share capital of rupees 100 crore or more and turnover of rupees 300 crore or more as on the last date of latest audited financial statements shall also appoint at least one women director. The next category is independent director. An independent director means a director who does not have any material or pecuniary relationship with the company or company's director. Basically, an independent director is a non-executive director of the company. Every listed public company shall have at least 1/3 of the total number of directors as independent director. The next category is alternate director. As per section 161 subsection 2 of the Companies Act 2013, the board has the power to appoint a director to be known as alternate director, to act in the absence of an original director during his absence for a period of not less than 3 months from India. The next category of director is known as additional director, the detail of which is given under section 161 subsection 1 of the Companies Act 2013, which provides that the article of a company may confer on its board of director the power to appoint any person as an additional director at any time who shall hold office up to the date of next annual general meeting or last date on which the annual general meeting should have been held, whichever is earlier. The last two categories of directors are small shareholder director and nominee director. Let us understand first the small shareholder director. According to section 151 of the Act, every listed company have one director elected by such small shareholders. For the purpose of this section, small shareholder means a shareholder holding shares of nominal value of not more than 20,000 rupee or such other sum as may be prescribed. Now let us understand the meaning of the term nominee director as per section 161 subsection 3 of the Companies Act, which states that subject to the article of a company, the board may appoint any person as a director nominated by any institution in pursuance of the provision of any law for the time being in force or of any agreement or by the central government or by the state government by virtue of its shareholding in a government company. Now dear students, I will explain the last two topics of our third module, namely meeting and resolution. Let us first discuss the meaning and types of meeting. A meeting may be generally defined as a gathering or assembly or getting together of a number of persons for transacting any lawful business. Company meetings must be convened and held in perfect compliance with the various provisions of the Companies Act 2013 and the rules framed therein. Now take a look at types of meeting. The types of meeting are being divided into two broad categories. Number one known as shareholder or members meeting and number two is known as meeting of directors. Although the shareholders or member meeting is being subdivided as annual general meeting, extraordinary general meeting and class meeting. The first type of members meeting is known as annual general meeting. As per the section 96 of the Companies Act, it is required by the company to hold meeting of the members to take approval of certain business matter. The meeting is to be held annually for seeking approval to certain ordinary business matters, which is known as annual general meeting. Basically, annual general meeting is an important annual event where members get an opportunity to discuss the activities of the company. Section 96 provides that every company other than 1% company is required to hold an annual general meeting every year. If the board fails to convene it, annual general meeting in any year, any member of the company may approach the prescribed authority, which may then direct the calling of the annual general meeting of the company. The second type of meeting is known as extraordinary general meeting, the detail of which is being mentioned under section 100 of the Companies Act 2013. All general meetings other than annual general meeting are called extraordinary general meeting, in short EGM. This means that all the transactions dealt upon in an EGM shall be of special nature. Now take a look at class meetings. Class meetings are meeting of shareholders holding a particular class of shares, which is held to pass resolution which will bind only the member of the class concerned. Only member of the class concerned may attend and vote at this class meeting. The second category of the company meeting is known as meeting of the board. Companies Act 2013 makes it mandatory for a company to hold board meetings for its proper functioning. Board meetings are crucial for a company's development because these formal meetings are held to devise policies, programs, procedures and strategies for conducting business operation and also to evaluate the expectations of the stockholders, that is, members of the company. The frequency of the board meetings is as per follows. The Act provides that the first board meeting should be held within 30 days of the date of incorporation. Thereafter, there shall be minimum of 4 board meetings every year and not more than 124 days shall intervene between 2 consecutive board meetings. Now dear students, let us discuss the last topic of this third module of Indian Company Act known as resolution, in which we will understand its meaning and type. Now as far as the meaning of the term resolution goes, a company being an artificial person any decision taken by it shall be in the form of a resolution. A resolution may be defined as the formal expression of the decisions of the meeting on a particular matter or issue having a binding impact on all the members of the company, provided it is in accordance with the prevalent company law. There are two types of resolutions known as ordinary resolution and special resolution. Now let us understand the meaning of the term ordinary resolution. As far as the meaning of the term ordinary resolution goes, ordinary resolution shall be an ordinary resolution if the notice required under this act has been duly given and it is required to be passed by the vote cast, whether on a show of hands or electronically or by casting votes. Now dear students, let us understand the meaning of the term special resolution. A resolution shall be a special resolution when A. The intention to propose the resolution as a special resolution has been duly specified in the notice calling the general meeting or other intimation given to the members of the resolution. The notice required under this act has been duly given and the vote cast in the favor of resolution are required to be not less than 3 times the number of the votes. Dear students, now I conclude the third and final module of the Indian Company Act 2013 by thanking you. I hope this video presentation will help you to comprehend all the concepts related to share capital, share certificate, share warrant, director, meeting and resolution.